One. Hello, everyone. This is Attorney Lin Wang in Trust and Wills. Nice to meet you again. Today, we have a special guest, Mr. Thomas Carroll from Remax in Massachusetts. He already has experience in the brokerage of houses for 32 years, and he has some questions about trust and wills in the experience as a real estate agent and broker. So today we want to have a discussion with him about this topic, about probate, estate planning, trusts, and wills. Hi, nice to meet you. Nice to have you here, Mr. Carroll.
Well, it's very nice to be here, Lynn. Thank you very much.
Thank you. So do you have some questions about probate estate planning?
I do because, probate and estate planning, it's always such a complicated matter for my clients. It's not something they do every day. They definitely need professional guidance. And a lot of times, we might be dealing with someone who's a foreign national nowadays because there's so much immigration into the United States. So different questions come up that never came up before. And one of the key questions I deal with, for people that with assets in the United States, what kind of legal documents should they have to protect these assets if they're either incompetent or they pass away, they're deceased?
Right. Like when we are incompetent, sometimes we think it for granted. Okay, my spouse or my children should take over the assets for sure, but whether that is not the truth, it is not the truth. Because, for example, if we want to buy a house and a lady approaches me saying, okay, I have a house and the house is under my husband's name, but we are married, I have the marriage certificate, and my husband is incompetent right now, I have the diagnosis from the hospital. Whether the lady can sell the house to me successfully? Of course not, because the lady cannot sign on behalf of the husband without other appropriate authorization. The only fact that the lady is married to the gentleman, the only fact that the gentleman is incompetent, do not qualify the lady for selling the house of the guy. So if we want to make sure if we are incompetent, our families can take over the assets without obstacles, we need to give them the financial power of attorney and medical power of attorney. And in these documents, we authorize our families and friends to take over our assets if we are incompetent. That's authorization. And they need the authorization to take over our assets when we are incompetent. And if we pass away, it's not for granted that our families will get our assets immediately and automatically. Instead, it will go to the probate court. The probate court is part of American court system. In this court, the government will figure out who gets what after a person deceased, according to the legal hierarchy of inheritance. So they will find out whether we have surviving spouse and children, if not, whether we have surviving parents, surviving siblings, nieces, nephews, cousins, like level by level. And this will take a lot of time and money. Usually it will take us 5 to 15% of the net worth of the estates to go through the probate court fee. So it can be a lot of money. And it can take us 1 to 2 years to finish the whole process. And it will disclose our information, the private information about our family, about our assets, about ourselves to the public, general public. They will disclose our information in their website, their papers, their magazines. So it will be disclosure of our privacy. So we need to have trust and wills to make sure if we pass away, the assets will be controlled by our families according to the trusts and wills instead of subject to the control of the government. So financial power of attorney, medical power of attorney, trust, and will are all very important documents to protect our assets when we're incompetent or if we pass away. And we should use the good documents to make our benefits to the best possible extent. Thank you.
So most people are quite familiar with a will, but they're not very familiar with a trust, what are the key differences between a will and a trust?
That's a very good question. Like when we talk about trust and wills, they always come here hand in hand. And what is the relationship between one and the other? When we talk about a will, basically it is a paper. It's in black and white, telling people how we want our assets to be distributed when we pass away. But they are not recorded anywhere. So when a person passes away with a will, the person's executors recorded in the will, usually the friends, the families, the deceased person trusted, needs to take the will to go to the probate court to verify whether the will is authentic or not. In case, the will is changed by other people out of inappropriate purpose. So it cannot show the true will of the deceased people. And this whole process will take some money as well. It will still take us 5 to 15% of the net worth of the estates to go through the will verification process in the government. And it will take us 1 to 2 years to finish the process. It will disclose the information about ourselves, our assets, our family, and the will itself to the public by the government. So it will be privacy disclosure. And if we have a trust, it is not only the black and white paper about how to distribute the assets, but we will record our assets in the name of the trust. For example, if I have a house, I have a real property, I will go to the county clerk's office of the deed to change the deed from our name to the trust name. And if it is a bank account, life insurance policy, brokerage account for securities, the people establishing the trust will go to the corresponding financial institutions to add the trust as the beneficiaries. So once the person passes away, there is no need to go through the probate to verify the contents of the trust documents because they already do so when they are still competent and alive. So it can save us the money, time, and privacy in the probate court. Also, when we only have a will, what can a will do? It can only say who gets what after our passing away, but it doesn't control when we are incompetent. In a lot of cases, people don't just die like that, they die immediately. No, we have time of incompetency. So if we're incompetent, who will collect the rent for the rental houses? Who will pay for our medical expenses, right? Who will pay for the mortgage? Who will repair our houses and pay the tax? That's a question. And the will does not control these questions. No one will control that with a will. But the trust doesn't only work when we pass away, it also works when we are incompetent. So the trust can authorize our families and friends we trust. The word trust, it really means a lot. So they can use the authorization from the trust to take over our assets, to collect rent, to pay tax, to repair the house on behalf of us. So while the will only controls when we pass away, the trust can control both when I pass away and when I am incompetent. So the trust can help us to distribute the assets successfully after our passing away and when we are incompetent. And there is no probate court process involved, no matter when I am incompetent or when I am deceased. So that's why trust is a more powerful tool than a will when distributing my assets. Thank you.
Well, it certainly gets you thinking, your own personal situation while you're talking as to, these are things that you really have to look into.
Right.
So you don't leave, whether you're incompetent or deceased, you don't leave your family with a lot of problems.
That's true.
Besides the fact that you can avoid the probate with a trust, are there any other advantages to a trust?
Yes, absolutely. Besides the process benefits, trusts can give us some asset protection benefits as well. For example, we have accumulated some assets for our families, for our children. What if the children get divorced in the future? What if the children have creditors in the future? What if they have a bad car accident and they have to pay for that? The money is our hard-earned money. We don't want our children to lose the money to their spouse, their ex-spouse, their creditors. In the trust, we can say even I pass away, I want the money to stay in the trust. And only the people I name can take the money away from the trust documents. For example, my children. They can use the assets for their own benefits. But their creditors and spouse cannot force them to use the money to pay off debts or to be divided in the divorce court. So in this way, the money will be kept in the family bloodline. And on the other hand, perhaps we have some black sheep in the family, unfortunately, or our children are still not that mature when it comes to financial management. So in the trust, I can give them guidance even when I pass away. I can say, okay, every year, my children can only use 5% of the trust property or 50K per year from the trust property in case they will just use up all of the assets in one sitting in a very short time in one lump sum. So the trust can control to protect and guide our children even when we pass away. And on the other hand, sometimes some people will say, okay, I have creditors as well. I am a small business owner. I am a lawyer. I am a doctor. I'm afraid of creditors. I'm afraid of that the clients will become creditors one day. So in this way, if we have the irrevocable trust, it can isolate the liabilities from the assets. The creditors cannot force me to use the assets in the irrevocable trust to pay off debts. And for some people with high assets, for example, high worth assets, some people who have assets beyond the threshold for the estate tax, they don't want to pay for the estate tax. What should they do? They can put whatever beyond the threshold of the estate tax in the trust, irrevocable tax avoidance trust, to avoid estate tax. So besides the process benefits, trusts can help us to protect our families, our beneficiaries, our children against their creditors and spouse, and we can guide them how to use the money. Irrevocable trust can even help us, help ourselves to avoid our creditors and avoid estate tax. So trust are really a very powerful tool, and they come in different purposes. They come in different functions. So hopefully everyone can find a trust very good for you, your family, and your assets. Thank you.
Well, that's really thought-provoking, your answer there. There's so many things that come to mind, if you're a family, if you own a family business, as your children get married and, spouses come into the picture and grandchildren. I will tell you, my wife and I went through this process 2 years ago because she had been the family representative for her parents' estate. And her parents were older and their attorney was older and hadn't really kept up with the estate plan. And
Okay.
it caused a lot of problems.
Oh, that's true.
So we learned a valuable lesson from them that you really have to re-engage. If you have an estate plan, you really need to look at it every 2, 3, 4, 5 years at the most, because things change.
Yeah.
And I know it sounds complicated to most people what you're talking about, but with a professional like you, you can simplify it and you can make their lives so much easier if they're incapacitated or their heirs if they pass away. So,
Yeah.
do you have any closing comments, Lynn?
Yes. Thank you very much for today's webinar, for today's presentation, and also like Tom has told about, because everyone will change. Everything will change. For example, some families, like they will have new babies, especially for the young families, and they need to have new beneficiaries. And estate tax changes. For example, next year, the estate tax threshold will be $5 million instead of $13.99 million. So it will subject many more people to the estate tax. And in this way, we need to change our strategies of estate planning. Our law firm will give every client of us a free consultation every year to review their trust documents to make sure they are still updated. So still, I want everyone to be protected well by estate planning instead of leaving surprise and trouble for the families after they're passing away. Thank you very much. Thank you, Thomas. Thank you, Al.
Lynn, thank you. Very important information, and we look forward to working with you in the future. Thank you.
Thank you. Looking forward to cooperation. Thank you. Bye.
Bye.